What's the line? Three of us, not people. That's good. Where? Oh, that's from the original. This is now. Anybody? Should be online. Guys, you want to check in? Check, right here. Yeah. 30 seconds. She not showing. She's not showing.
Yeah.
Arrington, are you with us? Sorry, this is a test, guys. We're just testing here.
Okay. I can see y'all. You can't see me?
No, we can't see you.
Am I muted?
Well, good.
Huh? Mark, am I muted?
You're good.
Okay. I've been dressed up.
What?
Can you turn on your camera, Arrington?
Where is that?
On your computer,
I know, but where on the computer?
on the Zoom screen.
Yeah, it looks like a video camera. It's an icon. Sometimes you can't see it unless you do your mouse over.
Show 'em.
Yeah. Is it the bottom left corner of your screen?
There's a mute bottom, there's a mute here.
Right.
Start video.
Yeah,
That's it.
that's it.
Charlie Brown said that.
Oh. I'm so technologically advanced.
Glamour.
You did it.
Okay, we're gonna get ready to start here, I think. Welcome back, everybody. Appreciate your patience on this, and we're going to get ready to start. This is a continuation of the previous meeting. And so, as we do with all meetings, let's just take a moment of silence. Okay, thanks. Need to certify a quorum here. We have 4, 5. So, as just to remind everybody, this is to grant or deny appeal reversing the zoning administrator's determination that section 305, the Montreat Stormwater Ordinance does not require a 30 foot stream buffer as long a stream section determined ephemeral stream by, you can't hear me? Okay, we're back to here to grant, deny, and appeal to reverse the zoning administrator's determination that section 305 of the Montreat Stormwater Ordinance does not require a 30-foot stream buffer along a stream section determined ephemeral stream by the DCDEQ. And I think where we left off was, I'd like to kind of do a little work here on our procedure and throw this at you. I'd like to ask Scott, if I could, Scott, what was the notice for this meeting?
The wording of the notice?
Yes.
Basically, I could bring up a bit of the presentation in a moment, but in essence, it was the posted notice and the mailed notice was a description of the nature of the appeal, basically stating that I, as the zoning administrator, determined that a 30-foot stream buffer was not applicable to the subject property based on NCDEQ stream determination and law, and the appellant is challenging that it is applicable, that the buffer is applicable to this segment of stream. That's it in a nutshell.
Okay. And that's why we're here. We did get a lot of discussion about whether the house should be built here or what this should do about the house. That's not where this is a very narrow law focus on whether or not this is an ephemeral stream and what the requirements of ephemeral stream are.
That's correct.
Is that okay? Now, all these other things about that we discussed would be applicable to another procedure, or another system. For example, if we want to talk about house stuff and we want to talk about where the house is put, if the house gets awarded and so forth, that's a perfect time to talk about it. We are going to be very narrowly focused and discuss only about whether this is an ephemeral stream and whether a 30-foot setback is required for an ephemeral stream. I'd be more than willing to hear feedback from both the appellant and the applicant. Have any comments, questions, or disagreements with that approach?
That's my understanding.
Well, Mr. Chairman, I think that the environmental harm here is quite relevant
I agree.
to your determination.
The potential harm is agreed, but are we
Excuse me.
talking about the
Hey,
environmental harm in this particular meeting?
Who is
I
speaking?
think we are.
We
Who
are
is-
not- we came, the notice was to define whether this is an ephemeral stream. Right? Is that not what we're here for?
That is
And
not
where it-
that is not the only issue, Mr. Chairman, and I would point out that I'm the one that filed the notice of appeal.
Yes, sir.
And that my notice of appeal encompassed the environmental harm, and that's what I intend to talk about briefly, because I did it before. But I
Right.
intend to talk about it again this afternoon.
That's fine. Well, as we spoke just a few minutes ago, I am not here to cut you off. So you have at it. I would like if we could be, we're going to go a while. So if we could be very specific and try to kind of wrap it up. So then what we're going to do after that, this is the deliberation period. After we get through with this is the evidentiary period. After we get past that, then we're going to go into the deliberation period. And then that's when we talk about whether, what, and when, and how, and so forth and so on. Everybody will hear it. People online will hear it. We will hear it. It will not be just, we sat up here and decided and we're quiet about it. I would like to encourage everybody on this board who have questions to ask questions during the deliberation period. There's nothing out of limits. I mean, during the evidentiary period, there's nothing out of limits here to ask questions. And I would like to encourage you to voice reasonings that you have in your mind. It's not required, but it certainly would be nice to hear from each one of us. I'd also like to change it up. Scott, you're looking.
I'll just make one sort of follow-on reminder to that. So any final ruling or decision or decisions that you make will ultimately need to be put into writing as part of the record. So just as you're deliberating, and if you have particular salient points or whatnot, if it's not necessarily to assign any one of you as a note taker, but just as a reminder that that's the ultimate product of this hearing, is that you all, the board, will need to prepare, however brief or long, a written record of decision.
Yeah, I have fun writing those. Okay, I agree. Any comments, questions from the board? You bet, please.
Sorry,
If you guys don't have any objection, we'll proceed.
There's one other comment. So that we have received a memo from the town attorney just in follow-up to a handful of questions that were presented last time. We've, I believe, distributed those to the board. We have copies for both the appellant and the property owner. I can speak to some of the specifics of those in a revised. I promise to have a shortened revised presentation just for any questions that you all may have of me, but just to just apprise the room that we've gotten some follow-up from the town attorney, at least on, again, the focus of the appeal, which, as we just discussed a moment ago, it's the narrow question of the applicability or not of the 30-foot stream buffer per section 305 and state law.
Any comments?
Well, Mr. Chairman, I just
Well, wait a
got,
minute, before you get rolling here, I got some housekeeping stuff.
Go ahead.
Everything that I'm looking at today in this packet, particularly the letter from North Carolina, Dean, what's it called, DEQ and NCDER. This is all in evidence now. Is that correct?
That's correct.
So everything in this packet is evidence.
Yes.
Okay. And this stuff over here is or is not.
Yes, that's
Okay. To be decided,
Same.
same. And this is application, right?
No, that was from the previous meeting.
Right.
That's already been entered into evidence.
That's all evidence too.
Yes.
Okay. Got it.
Okay, sir, please
Mr.
proceed.
Chairman, I got this 30 seconds ago. And if this is going to be discussed, I'd like to take a 5-minute recess and read it so I can respond to it.
I'd like to know who's speaking. Please identify yourself.
I'm Jim Hamilton. I'm the appellant.
Thank you, Jim.
It's hard.
Those of us on Zoom can't
It's a
see.
wide shot, so I can't really see who's talking.
Right.
it's so for your direction, we can take a break if both the appellant and the applicant wish to review the memo.
The memo from the town attorney. Mr. Hamilton, do we need a copy of it? You all have it. Where? In your packet.
It's part of your packet.
And
This is not that big document. That's from last week's meeting. It's within the paper clipped packet. Which page?
this 8-4.
H4.
No, 8, this is the 8-4 memo you're referring to.
8-4, that's today earlier.
This one.
Okay, I agree, and we'll take 5 minutes.
Thank you.
Let me know, Mr. Hamilton, when you're ready.
I'm ready.
And also, Mr. Burns.
Sure.
Let me know when you're done. And any board member that needs some time, let me know. Okay, everybody ready? We're good to go.
Mr. Chairman, I move that we bring the memorandum from Susan Taylor Rice, Pat Strauss, and August 4th into evidence or admitted as evidence in this hearing.
Do I hear a second?
I'm afraid I didn't hear what the board member said.
Okay, yeah, spoke
It's to bring this memo you just got into evidence for this hearing.
that we just read.
Second.
All in favor?
Aye.
All opposed? Ayes have it. Okay, so this memo from Scott, from the town attorney is to be put in the record.
Correct.
Okay. let's proceed.
Mr. Chairman, since the last hearing, I've made two submissions. One was a videos of heavy flow in my stream bed and into Flat Creek, taken last Saturday evening by my wife, Christina. And the second was a supplemental memo on the meaning of the ordinance under question here. I'd like to start off by asking that these videos, which probably total 30 seconds, be shown on the screen, so everybody will know what I'm talking about.
Josh, can you open, should be the folder Jim Hamilton exhibits under the A4 date. And yes, so that should be, yeah. So this is,
That's the wrong video, Mr. Chairman. That's the wrong video. That's the right one. This is a video showing water coming out of the culvert under the stream bed in my property and then rushing down the stream bed. And this is a video showing the water coming down after it's left my property onto a right of way and then through the culvert under Graybeard Trail and flowing into Flat Creek. The first video showed water coming out of the culvert from Mr. Burns' property into the stream bed on my property, and then flowing down that stream bed for maybe 20 or 30 feet. The stream continues on my property for 100 feet, but we showed about 20 feet of the stormwater flowing down the stream bed. The second video shows the water in the stream in the MRA right away, right after it leaves my property, coming down the stream bed there, going under the culvert on Graybeard Trail, and then going into Flat Creek. Everybody clear about that? Now, what these videos show is that there can be significant flow from a normal thunderstorm like we had last Saturday night. That flow will carry with it silt, and when a 3-story house is built on top of a stream bank, it's going to carry polluted water, polluted storm water into Flat Creek.
Sir, I really hesitate not to cut you off, but we need to keep focus of what we're here for. Is this an ephemeral stream or not?
Mr. Chairman, I'm going to turn to the legal issue, but I must say that is not the issue. Nobody is doubting that this is an ephemeral stream. That's not under consideration. What is under consideration is the meaning of this ordinance. And I have laid out in great detail in my supplemental memo what the ordinance means. Now, I hope everybody has had a chance to review that memo, because this is the crux of what I've got to say. But let me make just a few brief comments about it, and then I am more than happy to answer any questions about it. The second sentence of the ordinance says, section 305(1) says that a stream shown on certain governmental maps shall be treated as a perennial or intermittent stream. No doubt about that. That's what it says clearly. In that circumstance, the 30 feet setback rule applies. Now, the stream at issue is shown on relevant government maps. And those maps are attached as Exhibit C to my memo. And I hope the board has had a chance to look at Exhibit C and will see the stream is shown on these two maps, a topographical map and a soil survey map. Consequently, if there is no exception allowed, the 30 feet setback rule applies to the stream at issue. Now, I'm going to stop and see if anybody has any questions about that. Okay. Now, the third sentence of the ordinance indicates that an exception that would permit the elimination of the setback rule may be allowed, quotes, may be allowed, permissive, where the stream is found not to be a perennial or intermittent surface water. Now, I noticed in this memo, there is a question, and some of the board members raised this last time, whether in this third sentence, the phrase, this requirement refers to the requirement in the second sentence or the first sentence. I submit, because of the structure of this ordinance and the way the English language is normally interpreted when one paragraph follows another, that this requirement refers to the requirement that a perennial or intermittent surface water shall be present if the feature is shown on government maps. Is there any question about that?
I need for you to clarify what 305 you're reading from. The one I'm seeing and the one you're reading from don't match.
And just a reminder, if everybody can lean in with about an inch or two of the mic.
Well, I have no idea which one you're reading from. I'm reading from
Well,
attachment A to my memorandum.
the one that was Montreat Code of General Ordinances, Chapter K, Environment, Stormwater Management. And what you're reading as a statement for second sentence and third sentence is not what I'm reading on here for 305 general standards. Read your sentence two again, what it says.
I'll read the whole sentence. A perennial or intermittent surface water shall be present if the feature is approximately shown on either the most recent version of the soil survey map prepared by the Natural Resources Conservation Service of the United States Department of Agriculture, or the most recent version of the 1:24,000 scale paren 7.5 minute paren quadrangle topographic maps prepared by the United States Geological Survey, paren USGS paren. Okay. You with me?
Is it fair that you paraphrase that before?
I paraphrased it before.
That's what I thought. Okay.
If you, I can refrain from all paraphrasing. That's confusing.
It is, because that's
All
not
right.
what I was reading.
Okay. You want me to read the third sentence?
I've got it here in front of me.
All right.
An exception to this requirement may be allowed when surface waters are not present in accordance with provisions of 15A NCAC 2B dot 0233 paren 3 paren A paren or similar site-specific determination made using Division of Water Quality approved methodology.
We're working from the same statute.
I just, with your paraphrasing, I wasn't following what you were
Okay.
saying because it wasn't on this page like that. Makes a difference.
In this circumstance, that's before the board right now. The state has found that the stream is not perennial or intermittent,
Right.
but is ephemeral. As I said a few minutes ago, no question about that finding. Given that circumstance, the board may decide, and if I'm paraphrasing too much, you may stop me and I will go back. But given that circumstance, the board may decide that an exception may be allowed, say it again, may be allowed, that would eliminate the 30 feet setback requirement. Any question about that?
May be required
May be allowed, an
it's
exception
perennial-
may be allowed.
if ephemeral, it's not required, correct? Am I right about that?
If the stream is ephemeral,
Right.
the board has discretion.
No. Answer my question. If it's ephemeral, we don't need the 30-foot setback, do we?
That is not what the ordinance says. The
I think
ordinance
that's the
said,
crux of this motion. There. That's what I'm trying to get at. I'm having a hard time.
I'm here to help you. What can I do to help you?
Okay. Basically, we're here to grant or deny your appeal.
That's correct.
That the ordinance does not require a 30-foot stream buffer. If it's ephemeral, it does not require.
That is not what the ordinance says. The ordinance says, and pardon me if I paraphrase it, the ordinance says if the stream is not perennial or intermittent, in other words, if it's
Right.
ephemeral, an exception may be allowed. An exception may be allowed to eliminate the 30 feet requirement. But you have the discretion whether or not to allow that exception. That's what the English language of this ordinance says.
Okay, an exception, here's what it says. An exception to this requirement may be allowed when surface waters are not present. That's what it says.
That's what it says. And that means perennial or intermittent surface waters. And they are not present here because the state ruled that it's ephemeral. It's the same thing to say that surface waters, intermittent perennial surface waters are not present, and to say the stream is ephemeral. Same thing. Same thing.
I don't see that way. I don't see it that way.
Well, ma'am, the statute says an exception to the requirement may be allowed when surface waters are not present in
That's right.
accordance with a statute. The statute talks about finding whether or not a stream is ephemeral. In this situation, there was a determination that the stream was ephemeral. That is a determination that intermittent or perennial surface waters are not present. That's what the ordinance says.
So are you saying that intermittent, perennial, and ephemeral are synonymous?
No, ma'am, I am not. I am obviously having a great difficulty explaining what the statute means.
Right.
If a stream is not intermittent or perennial, it is ephemeral. They're
Right.
not the same. If it is not intermittent or perennial, it is ephemeral. And in that situation, where it is, a stream is found not to be intermittent or perennial, an exception to the 30-foot setback rule may be allowed. Not automatic. It may be allowed by this board. I'm ready to go on, but I want to make that clear. You have discretion to make this determination. It is not automatic.
Mr.
That's what
Chairman,
may be allowed means. May is defined by Montreat General Ordinances as being permissive. The word shall is defined by the ordinances as being mandatory. You have the discretion.
Mr.
Anybody
Chairman,
got any question about that?
Mr. Hamilton, would it help the board if you defined the differences between the three types of streams?
I'll be happy to do that. A perennial stream is a stream that runs all the time. An intermittent stream is a stream that runs part of the time. An ephemeral stream is a stream that runs when it rains.
Technically, it says it only carries stormwater in direct response to precipitation from water flowing only during and shortly after precipitation events, not headwater coming down. That's a different definition. I've got it here in front of me. That's what.
Well, I don't disagree with your definition. Pardon me, but I was paraphrasing. When it rains, and the water runs, you have an ephemeral stream. You saw the water running about 10 minutes ago in my video, and not running very slowly, running quite quickly.
I'll let Mr. Burns respond. I was just going to note if there are, I've again have a slightly revised and hopefully shortened presentation to run through certain aspects of state law, including definitions, but I'm glad to bring that up at the board's request, but I do want to
I think we can do this, but since Mr. Burns, if you have questions as well, you have the
well,
right. to
well,
ask.
it's procedure, and I think it'd be good for Scott to do his piece, but my procedural question is, Mr. Hamilton has repeated 3 to 4 times this particular point about the word may. And I don't know when is appropriate for me to respond. If he's making his presentation, it'd be good that he complete his presentation and I respond to that, but it's,
I would suggest that he respond when I'm finished, because otherwise it's going to interrupt train of thought and will be confusing.
Okay, let's proceed. If you don't mind, we'll let him proceed.
Well, to repeat myself, this board has discretion to decide in this circumstance whether or not it will apply the 30-foot setback to this ephemeral stream. But this board has not yet done that. And for Mr. Burns to build his house on top of the stream bank, this board,
Sir, are we talking about building a house on top of stream bank? We're here to define whether this is an ephemeral stream or not.
that is not the question, Mr. Chair. I'm telling
That's
you,
what with the notice.
there's
of
no
meeting was.
dispute that this is an ephemeral stream.
So the question is whether or not a 30-foot stream buffer applies to this segment of stream on this subject property or not. That is the, I think we're all in agreement with the state's the state's determination that this section has been determined to be an ephemeral stream.
Thank you, Scott.
Okay, please continue.
To allow Mr. Burns, and I'm gonna say it again, if you object to it, I apologize, Mr. Chairman. To allow Mr. Burns to build his house on the top of the stream bank. In other words, not 30 feet away from the stream. This board must affirmatively act to allow him to do so. And I respectfully submit that the board should not take this affirmative step here. I now want to speak a little bit about the environmental harm, Mr. Chairman. And if I can have 2 or 3 minutes to do that, I would appreciate it.
Is it substantially different than what you presented in the past? If not,
Probably not.
then it's probably redundant. So if you're going to make,
I have a question. In previous board meetings, when we speak to something as specific as that, we usually ask for an expert in that area to testify. Is that correct?
well, I may disagree just a little bit. He has the right to do that. If he's not a subject matter expert, he is the applicant and he can say whatever he wishes. And
All right.
it,
Okay.
I don't,
Well,
I-
if I may,
I understand.
if I may respond to that, I had an expert last Thursday
Mhm.
that testified at great length about the environmental harm. And also a citizen, Dr. William Seaman, came up and testified at some length about the environmental harm of Mr. Burns's project.
I did hear that.
Mr. Chairman, I am happy to stop now and answer questions because this is what I've got to say about the statute. I have more to say about the environmental harm, but I can forego that because I think you and other board members want to consider the statute. So perhaps I can answer any questions you have about that.
Other questions?
I think it would be best if we just say when we have a question, otherwise that we're not going to be able to finish tonight.
Well-
Questions online?
I just have a thought. I'm wondering if the point of why we're here is whether or not a construction on the stream bank of this ephemeral stream will cause environmental damage downstream to Flat Creek. That's where I understand that we all know what the ephemeral stream is. Question is, will building on top of it harm the environment? Am I way off base?
Are we
Madam
talking
Board
about
member.
building anything right now in this particular case? Are we talking about, in this case right here that we have before us, are we talking about building anything? We are trying to determine and the subject of was the disagreement and the right to appeal of Mr. Hamilton to the administrator's decision that it's an ephemeral stream. That's,
Mr. Chairman, I don't know how many times I can say that. That's not the issue. No one is doubting that this is an ephemeral stream. We're not disputing that. The question is, what does the ordinance mean? Whether this board has discretion and whether it exercises discretion is intimately tied to the issue of environmental damage.
This is Danny Sharp. I'm online. I understand that this has been designated as an ephemeral stream, and that makes clear sense to me. It makes clear sense to evidently a large portion of us. What I'm curious about is if we were to interpret this ordinance with the term may giving jurisdiction or giving the possibility of interpreting this, of changing this designation or denying that it is an ephemeral stream and therefore subject to the 30-foot setback. My question would be, what would be the conditions that we would use to determine that? Because that's not written in the ordinance.
Well,
So I'm confused by that. And the second thing is, I would love to see our township attorney rule on what the word may means for the purposes of this Board of Adjustment.
first of all, again, the issue, I'm not asking the board to determine whether or not this is an ephemeral stream. The issue is, since it is, may an exception to the 30-foot setback rule be allowed? In determining.
And I'm asking, under what conditions would that be allowed? And that's not written in the ordinance.
That is not written in the ordinance. The board has.
And so, Mr. Hamilton, I understand you're making a case for why that exception should be granted, and you're basing that exception on that case on environmental damage and other things. My problem is I'm not seeing those items in the ordinance itself. I'm trying to interpret the ordinance.
Well, obviously, when the ordinance says may be allowed, that gives the board some discretion to take into consideration relevant factors. The most relevant factor here is the environmental damage that's going to be done by a house on top of a stream bank. And I submit the board can take that factor into consideration in making its determination.
You keep coming back to the point, house is going to be on top of the stream. Is that a true statement?
The house is directly adjacent to the top of the stream bank,
Right.
which consists of large boulders that I placed there to protect the stream. Yeah. And I did submit a variance request to move it 5 feet from it to this board. And once Mr. Hamilton notified me and everyone else that he would oppose that, I withdrew that application so that that was not a venue to take it straight to Superior Court.
Mr. Hamilton, I read somewhere, and I can't find it, that in the construction of the house, there's actually a pole or a foundation structure already put on the stream bank. Did I read that wrong?
Yes. Several board members have been up there. Mr. Burns has laid his foundation. A corner of that foundation cuts into the stream bank. The bed of the stream is just a few feet beyond there. But I would say from the foundation to the center of the stream is probably maybe 6 feet. I'm guesstimating that. But if you look at the site plan that I submitted as Exhibit E to my last memorandum, you will see that Mr. Burns himself shows that his foundation is very, very close to that stream bed. And I suggest that perhaps the board members want to look at that site plan, which is an Exhibit E of my last memorandum.
Okay, I believe we've gone around and around the axle on that subject.
Can I ask a question? What I am thinking about in my mind is, and tell me if I'm right or wrong in the way that I'm interpreting this, that Scott Adams made a decision to approve this plan to build. Am I right so far?
That's correct.
And he did his due diligence by contacting Andrew Moore in April 27th, 2021. And Andrew Moore is an environmental specialist in the Asheville Regional Office. And he, is very familiar with water quality, regional operations, Division of Water Resources. And Andrew was very clear in saying if it's a perennial or intermittent stream, then the vegetative offset applies. If it's ephemeral, the vegetative offset does not apply. Now, Scott did the due diligence. I don't think that we can do more than have someone of his qualifications come in. So I don't understand what we're talking about. I don't
Well, ma'am-
understand what we're deciding.
Ma'am,
Yes.
Mr. Moore determined there was a ephemeral stream. Mr. Moore's interpretation of this ordinance does not bind you. Under section 301, this board has the authority to interpret section 305. And you should interpret it in accordance with what the language says, not with what in accordance with what some state official says. Look at the
State
language.
official,
Well, Mr. Moore is a state official.
and he's an expert. in his
He
field.
is an
And he
environmental
was-
expert. He is not a lawyer. And his interpretation, if that's his interpretation, is just wrong in
Right.
terms of the English language that's used in preparing this ordinance. This board is the arbiter, at least at this stage, of what this ordinance means, not Mr. Moore, not Mr. Moore.
Feel free to.
Okay.
Okay,
Appreciate
Just
everybody's
clarity.
input here.
you've been through the process, you made a determination. This board's being asked to affirm or turn back your determination.
That's correct.
No, no
That's-
A's, no B's, no extra. That's it.
That is the crux of the appeal.
Yeah, the other matters may be here. Everybody may have different issues, but that's another matter.
And
Did we
it's,
miss anything?
I believe you got a fair summation.
Okay,
now all these things that you bring out, please understand, I'll give you I support you putting anything forward that you wish. That's your right, you're a citizen, there's nothing. But there are always two sides of the story, such as may is permissive. It also means may not. It does.
Sure.
So
And
it's
that's what I'm
permissive
saying.
on one side or may not be on the other side.
Mr. Chairman, I agree with that. This board may grant an exception. This board may not grant an exception. You have the discretion. There are a number of factors you should consider in determining whether you exercise that discretion. I agree with you. May or may not. Up to you. But it's not automatic.
Okay.
I think what I need is additional information.
Which perhaps I could speak to just with a brief presentation, at least for the
Yeah.
benefit of the board and to field any questions.
With your permission, I think that's probably a good time. If you guys don't mind, let's go to Scott and let him fill in some of these blanks, if that's okay with.
But what points
Without
is he
objection.
speaking to?
So I just want to bring up it's basically a slight reordering of the presentation that I gave last time with some additional information that I've received since the last meeting. And I think I'm hoping it can bring some clarity to one, the law, and two, the process. So if I may, I'll just briefly go through this. You all have a copy of this for you. So really, if you could go to the next slide. So again, just a brief reminder of the subject property that we're talking about. It's there in the center in yellow. This was the public notice that was sent out to properties within 250 feet of the site. You could go to the next slide. This is a survey level view of the subject property in the dashed line there. The blow up on the upper part of the slide is just a notation on the latitude and longitude that was listed in the stream determination letter of what I'll characterize as the boundary between intermittent stream north of that, above that, and perennial stream below that and south of that. Next slide, please.
Would you put that slide back up? I'm not sure I can.
Certainly.
Scott, explain to me again what the blow up is.
So they're in the top center of the screen where it says flag at subsurface. That is simply it's a blow up of the area highlighted in yellow on that parcel. So that's a specific point of latitude and longitude that was cited in the June 28th stream determination letter from Andrew Moore with NCDEQ, delineating the point of departure between intermittent stream above that and ephemeral stream below that.
And up at the top in the corner, what does that say?
So that is a call out of at least the surveyor's note of drainage ditch. But that is the
it's-
surveyor's note on the survey.
Maybe the surveyor's note, that is not a drainage ditch. That is 100 feet of stream that is on my property. It's a stream that flows every time it rains hard.
Right, an ephemeral stream. Next slide, please. So again, just on the bottom there, the appeal summary, that was my attempt to really just fairly succinctly summarize what the appeal is. I've made the determination that the stream buffer is not required per the stream determination of ephemeral and the methodology that was used to do that. the appellant, Mr. Hamilton, is countering that a 30-foot vegetated stream buffer is required. At least my summation of this is on hearing that it is shown on a map. I will make a note that the maps are a first level of review. The whole point of the stream determination is for an individual property owner to be able to say, yes, I know it's shown on a map. If I didn't want to, question it any further, I would apply the buffer, because the assumption if it's on the map, it is assumed to be perennial or intermittent, and the buffer is applicable. With a stream determination, that's a secondary, more specific level of analysis from NCDEQ, basically, that can determine one of those three stream types. So if it's determined as ephemeral, every communication that I've had from DEQ as a matter of law states that that is not required. If I could go just a few more slides.
Mr.
Just to
Chairman, may I
walk you
ask
through it.
Scott a question?
Let's let people finish. We
All right,
really
that'd be
would be
fine.
here till 10:30 or 11.
I'm happy to wait.
Okay,
Okay.
so I promise to try and walk through this as quickly as I can. So these are excerpts from the town attorney's memo, which was received earlier today here by town staff. So it's just basically stating the zoning administrator as stormwater administrator interpreted the application of the Montreat Stormwater Ordinance for the Lot 778 project, and the final zoning and development compliance certificate. The zoning administrator findings included the following: as proposed, this project meets all relevant requirements of the Montreat Stormwater Ordinance. Further in her memo, she's noting procedurally, James Hamilton has appealed the decision of the zoning administrator, and in hearing this appeal, the Board of Adjustment can reverse, affirm, or modify the zoning administrator's decision. Next slide, please. This is further content from the memo. This is just her, basically reiterating section 305.1 of the stormwater ordinance, and that is her highlight there in the third sentence, this requirement. She's stating, my understanding is that James Hamilton has raised a question about the meaning of this requirement highlighted above. Specifically, does this requirement refer to the first sentence in section 305.1, or does it refer to the second sentence? Mr. Hamilton has provided a memorandum setting out the interpretation of this requirement as referring to the second sentence. This is her statement. One more slide in. Next slide, please. Thank you. So this is continuing further in her memo. She's stating the interpretation of this requirement as referring to the first sentence could be as follows. The first sentence sets out the requirement that the Baltimore area be a minimum of 30 feet landward of any surface water. The second surface clarifies that when surface water is present. The third sentence provides an exception to the 30-foot requirement when surface waters are not present in accordance with section 15A and CAC, et cetera. She's also stating, it appears that the zoning administrator interpreted this requirement to refer to the first sentence in the section 305.1 and determined that, and I highlighted this here for just purposes of clarity, an exception from the 30-foot requirement was applicable based on the letter from Andrew Moore, that's the stream determination with NCDEQ, and the exception language in the state statute, which again is 15A and CAC. The Board of Adjustment can consider whether this interpretation is correct. However, the determination of the ephemeral stream is not before the board. That I think everyone's in agreement with that. If I could go a few more slides in just to walk through. So this is just a reference to state law that says all stream determinations are done by the Division of Water Quality or Water Resources. Next slide, please. This was the email that I had received from Mr. Moore with DEQ in April, just as Ms. Chastain mentioned, doing due diligence. Next slide, please. Again, this is an excerpt of the actual ordinance language with a call out of the state's methodology for determining streams. Next slide, please. This is a screenshot of the state's literal determination criteria. So it's a points-based system. If I could go to the next slide, please. So again, this is the stream determination letter regarding the subject property. Next slide, please. again, with a site overview, that notation in the center of the screen, that's the same notation on that survey marker that I had up front, just noting the lat long. Next slide, please. So changing focus for just one moment, I just want to give you all another quick example of the exact same methodology being applied or being applied to another property here in town where the question came up, hey, I'm on a stream. What is the stream? So this illustrative here was something I created to send to DEQ inquiring about the subject stream segment. And this is here in town at 304 North Carolina Terrace. Next slide, please. This is the stream determination letter. It came back as ephemeral. Next slide, please. This was in a following email from Andrew Moore with DEQ. The feature was determined to be ephemeral, which means it is not considered a stream. That was his direct statement in relation to that same application of the methodology. If I could just get a couple more slides just to briefly mention, to respond actually to a couple of questions that came up in the last hearing. So you'll remember I prepared this sort of color-coded map last time to illustrate various property owners in immediate proximity to this. The one that's highlighted there in orange with the dashed line around it is owned by John Richardson, who supplied a stream determination letter that he received on that property in 2015. On the next slide, which determined that the segment along his property was ephemeral as well. So the question about what is the stream doing outside of the subject property and immediately adjacent to that, there was a stream determination made for that segment on the property that it was ephemeral as well. There was a secondary note in there that water basically appeared at Graybeard Trail as a perennial spring of sorts. So I'm just making that differentiation to note that at least for the majority of the segment on the property south of there, it's been determined as ephemeral as well. If you could go to the next slide. This is just a quick illustrative of the subject parcel that was mentioned in that determination letter. If we could go to one more slide. So this was, again, a follow-on email from Stan Aiken with the NCDEQ Asheville office reiterating the applicability of the 30-foot buffer to perennial and intermittent streams, not to ephemeral. If we could go to the next slide, please. So this is what he referenced in his email. This is the specific stormwater law for areas that are subject to an MS4 permit, that being municipal separate storm sewer. That's what Montreat, that's the stormwater program. So the specific mention of vegetated setbacks, again, perennial or intermittent, relief from this requirement may be allowed when surface waters are not present. So going to the next slide, I believe there had also been a question from a board member on the specifics of the section of NCA or 15A NCAC, which is the, I guess it is the origin of what's in the town's ordinance. So I just highlight it here. Interestingly enough, it is classified as the News River Basin Protection Rules. I can't necessarily speak to how DEQ draws its references, but that is the reference that is in the town's ordinance. Exception when an on-site determination shows that surface waters are not present, it's just highlighted there. This is actually from the section of state law that is referenced in the town's ordinance. I'd made a note earlier that this actual section has been updated, and I have just a couple of quick shots of that actual updated law. It's substantially the same language. If we'll go to the next slide. So these are the working definitions if anyone wants to come back to that from the current new law. And the next slide. So again, just the definition of buffers. This is again specific to the News River. Not quite sure why that's linked for reference, but that is what DEQ was using. And finally, the next slide, please. So this this was previously in 15A NCAC. It is now 15A NCAC 02B point 0714, and it states exemption based on-site determination. And one of the criteria that it states for exemption of the 30-foot buffer is the presence or determination of an ephemeral stream. And I believe that if we go to the next slide. So that's the substance of what I wanted to speak to. I've got additional information that I had presented last time and have a handful of other things should questions come up, but essentially what I'm presenting is evidence based on, it's based on the rule of law. It's the rule of state law. And I will just state now, and I could state later, that property owners and the larger community rely on this for predictability and making decisions about their property, about their individual properties. I will also just briefly make a statement that I think you're hearing, at least in the appellant's commentary, a request for the rule of like, as in, I don't like these state laws, or I'd like the board to make a ruling that's contradictory to state law. That's what I'll briefly offer and take any questions.
May I now ask?
Yes, sir,
Yeah.
please. And both parties can ask any questions they wish. So proceed, sir.
Mr. Adams, the third sentence of section 305(1) says an exception to this requirement may be allowed when surface waters are not present in accordance with the provisions of 15A NCAC 2B.02333 or similar site-specific determination made using Division of Water Quality approved methodology. The phrase in there is an exception to this requirement may be allowed. What is your interpretation of the words may be allowed?
It's that it is optional and flexible.
It is.
It is optional. It is optional and flexible. I mean, that is, if we're defining the word may, it's not prescriptive, but again, that is a single word versus what I have reviewed in my consultation with the state Department of Environmental Quality and both their laws and practice regarding ephemeral streams.
Mr. Chairman, I agree with Mr. Adams' interpretation of the word may. And I'm suggesting that this ordinance is what controls your decision here, not the practice in some other jurisdiction. This is a Montreat ordinance, and this controls what you have to do.
I will may I briefly respond to that. I'll just,
Yeah, I think we both sides have made their positions clear, and I think it is the role of this board to take that into evidence and decide the weight that this evidence, whether it's evidence that you brought through or it's there's the discretion. We will determine who's as a board. And that's what the discretion is. Can you state what you were saying?
Yeah, can you back up one slide? The highlighted area, and I'm reading from what it says here. An exemption based on the site determination. Surface waters that appear on the maps listed in sub-item 3A of this rule shall not be subject to this rule if an on-site determination shows that they fall into one of the following categories. I won't read A and B, but C, ephemeral streams. That says exemption. Doesn't say can or you may. It says it's an exempt. That seems to be pretty much nail on the head for me.
But that statute is not controlling in Montreat. What is controlling in Montreat is the language of this ordinance. That statute involves the News River Basin, wherever the heck that is.
I feel like that we're sort of having a back and forth arguing thing, and I don't think that's appropriate. I think that what this board wants to do is hear everything you have to say. We want to hear everything you have to say. We want to hear everything you have to say, and we will make a determination.
Well, I have one exhibit, I think that,
would it be, now, is this to
Yeah,
rebut?
Mr. Hamilton's finished. I have,
Okay. If it's to rebut, if you
Yes.
could just hold it and I'll come to you. Go ahead, sir. Do you have anything else that you would like to say?
No, Mr. Chairman, but we've gone an hour. Is it time for a brief recess?
Yeah, let's take another 5-minute recess and let's make it 5, okay? Or less.
It's the source of. Yes. Yeah. Right. Yeah. Right. 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 Was I not clear on that, or just the crux of the ask, or the Mhm. Right. Right. And my point is that the state law very clearly says. Right. Shall not. Well, and the ordinance is it's out there. Really? I mean, you see where I'm doing what I'm doing is saying, let me find the most up-to-date section of state law. That's yeah. Right. Yeah, well, yeah. Right. Okay. Yeah. Yeah, no, I mean, yeah, no worries. I hope I'm being semi-clear. Yeah, sure. Yeah, no, I mean. No. It's the rule of law versus the rule of life. What's it? Right. Yeah. I mean. All right. Huh. Yeah. Yep. Do I need to even mention, I mean, they've received all this and just.
But we. I agree.
Yeah, if you wanna. Yeah, I mean, just if you want to just keep it official, like, I don't want to give any appearance of like, I'm over here and then I, happen to get forwarded it, like, it was sent to you, so you speak to it and you just play by the rules, all above board. Yep. You're on what? Oh. All right. Oh, yeah.
Hey, Scott.
I'm trying to be straight and narrow. We'll see.
Are you getting the pizza? This came up.
Oh my gosh, just now. Wow. Oh, yeah.
That's.
Man,
Yeah, that's.
do they have a cat cooler?
No.
I'm just all.
Test that.
It's like a paper.
No, it's a review.
Okay. Yeah.
Oh,
Gotcha.
we moved up here. But. Yeah.
If everybody can kind of mosey in here, we need to get this on the road. Somebody asked if I brought the pizza. No.
That's never good. Batteries.
He's going to get. Oh, got
Oh, a gavel. Oh, wow.
You know where the secret hiding spot is. There you go, kid.
Okay, I think we've discussed this quite a bit. I'd like to give you guys one final opportunity. Both of you, Scott, all three of you. Anything else you'd like to add to the current proceeding?
I think it's Mr. Burns' time.
Well, I have one simple exhibit. And this, I'll pass out.
Get on your mic, please. Sorry.
That's Montreat. The purple are streams. They're everywhere. What's on the state maps is there without the scientific tests of lot by lot because it's impractical for them to do so. And so if you were not allowed to have the state do the more scientific interpretation, then you would not have complete evidence, and many, many people could lose rights to their property. That third sentence is there for the purpose of justice. Thank you.
Tell me where your property is relative on this map.
And Mr. Slaski, if you could just pull your microphone too, please. No worries. What-
Yes, that's that's EW 11, Exhibit W11. You'll see sort of what looks like a delta, boomerang type shape. Up there are several lots in your upper right-hand corner.
Yep.
That's the general area. I think you have Graybeard Stream and I think Little Slady. Or the primaries up there.
So your lot you're talking about, can we see it on this thing or not necessarily?
I left a magnifying glass at home.
Oh, I got you. Anybody?
I think the purpose of it was just to show how many streams there are
Oh,
in the
gotcha. Okay,
area.
that's what you're trying to tell us.
That's right.
Oh, gotcha.
That's all.
Next. Thank you, Mike.
You're welcome.
You done?
I'm confident that the evidence has been presented addresses the issue that's before the board.
Mr. Hamilton?
Mr. Chairman, I think there's agreement, certainly Mr. Adams and I agree that the words may be allowed give this board discretion whether or not to apply the 30 feet setback rule to the stream in question. I think the issue before you is whether you follow the opinion of some state official or whether in exercising your discretion, you remember the testimony of my expert, Mr. Zan Price, and Mr. William Seaman, Dr. William Seaman, who appeared last week and said that placing a house on top of a stream bank, and this particular stream bank, where there's strong water flow, would create environmental harm. Remember what Mr. Price said. He said this stream may be called an ephemeral stream, but it acts just like the intermittent stream that is 75 feet above it, because the drainage area here for the stream is something like 70 acres. So that's the issue before you. Whether you want to affirmatively decide that you want to allow a house to be placed on top of a stream bank that's going to cause environmental harm, or you don't want to do that. Thank you.
I agree that that's the issue. It doesn't matter if it's Niagara Falls or a little trickle in the woods. Will the water coming from as a result of the construction that close to the stream bank pollute the water enough so that it becomes an environmental hazard?
Arrington, if you don't mind, we are in the evidentiary period.
Okay,
That would be remarks for the deliberation period. And
Okay.
have your say so all you want to.
Okay.
Please do. If that's okay.
I
Don't
don't
make anybody mad or cut anybody off. I want to separate that.
Thank you.
Anything else?
Okay, thank you. I'll be quiet.
No, please don't be quiet. We'll just do it at the appropriate time.
Hold that thought.
Yeah, hold that thought.
I got that thought.
So if I could bring back my presentation just to speak to one slide, I promise just one slide. And if we could go to pretty much to the bottom, and then we'll just work our way back up. So if you go clear to the bottom. Yep. Okay, let's go up one more. One more. Sorry, one more. One more. One more. There we go. Thank you. Yes. So I just wanted to bring this slide up. This is from I think I just want to clarify any possible confusion over stormwater impacts that we've seen in the videos now, and I think those videos through various stages at least show that some erosion and sediment control measures, which we've seen in the videos, could be corrected and addressed by the subject property owner. That is in construction, stormwater questions and erosion and sediment control. In the long term, this was a set of calculations that I reviewed as part of my approval for the subject project. I won't use the H word. I just highlight there that the applicant has demonstrated that the capacity of 2 stormwater control measures that they've proposed for the site have the capacity to address 2,350 gallons of stormwater in a given storm. That exceeds what their estimated runoff is from their impervious surfaces, i.e. their porches, the roof, any basic hard built element of the house. So I just want to quickly highlight that the discussion of the phrasing long-term environmental damage from runoff or from what have you, it's been documented and addressed, at least in my administrative review of that. Again, I'm just speaking, everything that I've been speaking to has been to what I took as direction from the state environmental agency, from state law, and from the most up-to-date state law reference, which is indirectly referenced in the town's current stormwater ordinance, that's section 15A and CAC 0233. So with that, I'll leave it at that.
Mr. Burns, are you saying your pre-post is the same, your pre-post stormwater is the same, or that the discharge of the velocity of the discharge in a storm event is static because of your stormwater retainage on the site?
Well, there's only 32 feet of stream
Right,
showing on my site. The rest of it's in culvert.
right.
And basically, I've worked to control that nothing gets in there. I have enough flat that have very good erosion control potential because I've got so much flat on that site. So I'm not anticipating a kind of erosion problem.
There's not, in other words, what I would hear you say is you're not concentrating the flow. You're not
No.
concentrating the flow or channeling the flow. It can spread because you've got the land area to do that.
Yes, I have actually directed building boulder walls adjacent to streams.
Yeah.
Raise the edge so the edge is not sloping into it, but away. And so it takes water in a number of places down to where it's in a vegetative area that can be absorbed.
But impervious, how much is impervious surface increased by this project?
That's in those calculations
Okay.
that Scott did, and that's.
Yeah, I just couldn't read the numbers. It's minimal.
Yes, well, we can bring it back up. I
That's
can
all right. I
actually-
got it. If you did the calculation, I can see it right here in a minute.
So
It's the driveway, parking, walks.
Yeah.
Porch roof.
Is driveway asphalt, concrete, or some other surface?
Well, the driveway is calculated as being impervious.
That's what I wanted to know. Thank you.
It has to be unless you,
Yeah.
got a more expensive thing.
Right, gotcha. That's what I was trying to get to. Thank you.
I'll just quickly note that as part of the stormwater, so that I think to your specific question, the applicant has proposed essentially a concrete stormwater cistern immediately adjacent to the house, and as a secondary treatment, essentially a rain garden below that.
Right. Which deals with the velocity and channel, all those issues.
That's correct.
Gotcha.
From the impervious surfaces
Created
on
by
the
the
house.
development, yeah.
Yes.
I hate to be a pain here, guys, but both sides are now talking about this house again. We
Well,
need to talk about, we need to focus on what we're here.
Yeah, you're
And
right.
does anybody have any other questions about the determination of the zoning administrator, whether or not this is ephemeral stream or not?
The
Mr.
applicability
Chairman,
of
for
the
the fifth
buffer.
time, that is not the issue before this board, whether or not it's. I do want to respond. to
That's in
what-
the notice. That's what we were told that we were having this meeting about, sir.
I beg
And
your
you
pardon.
you got that notice as
The-
well.
Well, Mr. Adam, first of all, Mr. Adams' description of my appeal is not defining. My appeal is what I say it is. Right?
Yes, and
I
we
can
can,
appeal what I want.
you bet.
I'm not bound by what he said.
No, you're not.
Secondly, he doesn't think that the issue is whether or not it's ephemeral. Everybody agrees it's ephemeral.
Well, then then if that's the subject of this meeting, let's go ahead and vote. It's a,
The issue is, it's not the subject of this meeting, Mr. Chairman. The subject of this meeting is whether or not the ordinance allows you to have discretion to apply the 30-foot setback where there's an ephemeral stream. I've said this 10 times, and if I fail to communicate, I am sorry, but there's no other way I can say it. I want to say one more thing in response to Mr. Adams, and then I'm going to shut up. I'm sure that'll make you happy.
I'm not, I never requested you to shut up. I asked you not be.
Not in those
redundant.
terms, Mr. Chairman.
I didn't ask you. I asked you not to be redundant. That's what I asked.
I'm
I
going
asked
to
to
make.
focus on this, on what the subject matter is. That's what I
I'm
asked.
going to make a point I have not made before.
Please
I'm
continue.
there responding to Mr. Adams. He talks about stormwater vaults and things like that. I just want to point out, 75 feet up the hill where the stream is classified intermittent, you could not build a house on top of the storm bank, whether you had 5,000 gallons of stormwater control. And as my expert, Mr. Price, testified last week, the stream, the ephemeral stream acts just like the intermittent stream. You've got to consider these environmental matters when you're making your determination. I'm through. Thank you.
Okay, thank you, sir. Anything else from you, sir?
I would just state that all of this argument about sentence number 3, the state has these tests they do with scores on them because that, and not whether it's blue line, that is what the law recognizes as best evidence. That's the audit. That's the autopsy. That's the examination of the rocks in that spot turned upside down, the water in that spot tested. And that's the best evidence is a test. And the notion that you should not be allowed certain people to have the best evidence is silly. Thank you.
Okay, anything else from anybody? Are we ready to proceed? Yes, we do. We have 2 additional informational things we'd like to present, just put into the record.
I received communication from 2 members of the public, Miss Jean Norris and Mr. John Crawford. I presented those or sent those to all the board members, Mr. Hamilton and Mr. Burns. I leave that to the board whether or not to enter these documents into the record. I don't believe Miss Norris or Mr. Crawford are here. Miss Norris is here. Okay. So Miss Norris is here. I don't believe Mr. Crawford is. So I'll leave that to the board.
Are we or are we all familiar with those two letters?
Yes.
All of us are? Everybody ready? Do I hear a motion to allow it?
I move that we allow it.
Second,
Second.
all in favor, say aye.
Aye.
All opposed? Ayes have it.
No,
Ah.
No,
no.
ayes have it, but we have a no. Thank you, sir. Okay,
Well, Ms. Norris is here. Does she want to speak?
yeah, at this point, you have not been sworn in to this? If you could do, I'm going to place that to you guys. I'm not against hearing it, but I really, we really need to not be redundant and continue. So I have no objection if the board doesn't.
I have an objection. This is Danny again, in that it doesn't appear to me that the communication that we received from Ms. Norris is relevant to the property that we're discussing.
So Danny, are you saying you're moving to not accept this testimony?
Well, I voted against accepting it.
Okay.
But I am recognizing the reason I voted against it is it doesn't appear to me to be relevant to our discussion.
I'm following it. Thank you. Yeah,
Here again, then we can file that as being included in the record. And we can weigh that evidence as being relevant or not. Do you agree with that?
Yes,
Since we voted in.
yeah, we got it, but we don't. need to
Okay,
wait anymore.
any other questions? Are we ready to proceed on to okay, well, here we go. Now, we're going to make this a little bit interactive. This is where we state opinions and throw out things back and forth. Everybody will hear it. I don't want to limit you guys asking questions, but we really need to keep those at a minimum. This is the deliberation period and not the evidentiary period. If you have a question about things, we need to really kind of keep it straight and narrow. So if that's okay, then we're going to proceed on to the deliberation period. Anybody like to start? Can I ask a question before we do that? Just for my own information. Has the course of the stream changed since the work has been done? Has the amount of water coming down the ephemeral stream changed since the work has been done? Have any new contaminants or pollutants been introduced to the ephemeral stream bed since the work has been done? Those are three questions I would just like to know for my own edification.
Uh,
They're not leading, please. You understand, I'm not leading you either way.
Mr. Chairman, I'll answer that in two ways. First of all, in the stream bed in my property, right below the culvert coming out of Mr. Burns' property, as of a measurement 2 or 3 days ago, there is 10 inches of silt. Of course, the major problem will arise after the house is built on top of the stream bank, a 3-story house. Then you're going to get pollutants in the water, and the constituents of the water are then going to change. Thank you.
So the three questions, that's just your comment back. Those are the three questions to answer those three questions. Okay, well, then that's my final question. Let's deliberate. Anybody like to start?
Is now the time?
Yes, ma'am. Please do. Please do.
All right. I think I remember what I said. I think it matters if it's Niagara Falls or a trickle stream going down. House is built that close to a stream or Niagara Falls or trickle. It's going to have an impact. The construction is going to have an impact. Once the house is up, it's going to have pollution is bound to have an impact. And this goes down to Flat Creek. And I strongly believe that this is an environmental hazard.
I think the exemption is allowed in that wherever water flows during a rainstorm, like, anywhere on your property, you wouldn't be able to build within 30 feet of that. And we can't control where water flows and not just intermittently, but wherever it flows when it rains. And that's why the setback is exempt for ephemeral streams. And the other thing that goes through my mind is the integrity of the town of Montreat when they issue a permit based on good information, due diligence to a builder or a property owner. And that property owner goes to a bank and borrows money and signs contracts. And then the town comes back months later and says, we were just kidding. It's not appropriate. And I don't think it's healthy for a town to get that kind of reputation.
Mr. Chairman, may I respond to that?
Is it in the form of a question, sir, for her answer, her deliberation?
No, no. No.
Okay.
May I have, Mr. Chairman, may I have another question?
Yes, I'm,
For the board, yeah, that question. But
We're done with that.
the hearing part is done.
okay.
Can I ask a question?
Hold on just a second. Let's rule on what's been put forth here. If the board feels like that's what is not appropriate, I'm
That's just my
willing to.
personal opinion.
Okay.
Each one of us, I've been explained to, when I took this role, is that each one of us acts as a singular
That's right.
arbiter of truth. We are quasi judicial. So we rule as a judge, singularly. But we have very different opinions. And that's democracy at work. I'm just saying what my opinion is for the benefit, edification, to be honest. So you'll know.
And just to add on to Martha's, if Martha has an opinion, which I could agree or disagree with,
Right.
that's part of the discussion. I don't particularly want this board trying to, every time you tell me your opinion, you get challenged on it. Because then I'm not
It's
going to
just
get
my
your opinion. I'm not
It's
going to get
just
your
my
opinion.
That's all.
Okay,
That's not what the purpose of it.
I'm good with that. In my opinion, I was given the opportunity, but if this is the deliberation period, if that's what the board feels like it, then I'm going to
Yeah.
agree. Any
is.
comment from other board members? Arrington?
Yeah, I mean, I have to wonder why all this happened with the town and permission was given here, there, yonder. This situation was not considered to begin with. It seems to me that we've got the cart before the horse here.
I agree.
Again, my thought, my thought.
I agree.
Martha, we can't hear you.
Oh, I was just telling Scott that I want everybody to be able to say how they feel about it, what they think about it, but it doesn't require a comeback or
Okay.
I agree with you,
No,
any of that, right?
This is Danny again. I'll give a couple of comments if I may.
Please.
Watching construction in our area, neck of the woods in Montreat for now 25 to 30 years, and watching road construction in our town of Montreat, I can say that I've never seen any construction project, no matter how well it was fenced and silt was attempted to be managed, where there wasn't some kind of residue going into streams. I think we try to ameliorate the problem as best we can, but I don't think we ever eliminate it. And I think road construction is a major issue in Montreat for silt to come into stream beds. My other observation is during major water flows and major storm events, I've also observed lots of mud and silt coming into the stream beds and going into Flat Creek. It's just an ongoing process of drainage into Flat Creek. So I'm not so concerned about silt coming into streams if it's an ephemeral stream. We have a lot of them in Montreat. They're designated that way for a purpose, and people make their decisions based their building and land use decisions based on those determinations. And so I tend to agree with the North Carolina statute. It does not give us the authority to make a decision to choose to deny the ephemeral status and put the setback requirement there. I don't see that as an option for us. It has been determined as an ephemeral stream, and that's how I interpret the statute, both 503 as well as the North Carolina statute. I don't think we have the option, as I see those two statutes, the North Carolina statute and the Montreat statute, kind of working together. I don't see that as an option for us.
Thank you.
What I gotta say, Mr. Chairman, I move that the board approve or affirm what is your decision? What is your title?
Zoning administrator.
The zone, okay, there we go.
Either deny or.
Okay,
the appellate.
Mr. Chairman, I move to grant an applicant to deny the appeal to reverse the zoning administrator's determination that section 305 of the Montreat Stormwater Ordinance does not require a 30-foot stream buffer along a stream section determined ephemeral stream by NCD or DEQ, whatever it says.
What did he say?
So are
Whatever
you,
that thing says,
What'd you say?
are you moving to deny
I am
the
moving
appeal,
to affirm
the
what Scott's
request-
already denied the appeal, affirm Scott, and no buffer applies. Now, how you get that out of that, I don't know.
I wrote it.
I would second that motion.
Okay. Before we have the vote, can I have my deliberation?
Sure.
Okay, good.
All I'm trying to do is move it along.
I'm going to move along and try not to be redundant. I'm being particularly specific because I wanted this thing to move on in the way that we asked. I am not trying to disprove, question. I'm here to deliberate. I think all of these issues, as a matter of fact, depending, I may or may not be on your side, but I think all of that is very appropriate. You brought it up and you said that there was a variance that was initially requested. That's what you said, right? And then it was withdrawn, right? Is that correct? It was
Yes.
withdrawn? Okay, great. It was withdrawn. All of these things we're going to hear again if a variance gets put forth. And that's the time when we have the most discretion of whether the things that have to do with the building of that house, that's when it should be determined. That's when it should be discussed. If a variance, the stream determination should be a very simple thing. But the things about whether the house is going to pollute and whether it's too close to this and so forth and so on, that's all related to the building of the house. if a variance we'll discuss it all again. You'll be able to, and at that point, you can bring these issues up. Bring it up. Say it shouldn't be this and it shouldn't be that. And I think it's actually a good thing for this town that we are talking about whether or not we should protect our environment and whether or not houses should be this far from an ephemeral stream or not. Those are all good things. And I think we should discuss those. It's not for this hearing. That's not the subject matter of the hearing, but I want you to understand, I haven't made up any mind whatsoever if any variance gets applied on whether or not you're breaking the rules or not, or whether or not. And I had the final question that I didn't ask was, and the ask was, for this appeal, do you contend that the Board of Adjustment must use discretion to override or make more restrictive current town, county, state definitions and requirements related to ephemeral streams? Now it's a question I posed myself. Okay. So I want to hear this. You're not being cut off at this point if we decide this is an ephemeral stream or not. You're going to have all the, should Mr. Burns continue, and remember, it has to be for both. I've got to be fair to him and you both. We got to be fair, him and you both. We're not going to take a side and run with it. We're going to listen to both sides. So I want you to understand there will be an opportunity if that happens. I just want to limit this. We spent 2 hours still talking about the house when we're trying to determine the stream determination. So I would like to, if I could, in my deliberation, I'd like to say, I don't want you to give up the ship. I'm not against what you're trying to do. I don't have an opinion. I'm not against what you're trying to do. I don't have an opinion. I want to do what's right. Let's determine the stream first. And then if it goes, let's talk about it in a variance, which is more applicable than this stream determination.
Would you like my response?
I don't think I'm deliberating, sir.
Well,
I just heard the board. I just heard the board say that, we don't need questions. I concurred with the board. That's my deliberation.
Hear what you have to say.
Yeah,
But
I'm telling you my
afterwards-
opinion.
Afterwards, it'd be totally appropriate for you to come and say, well, you said this and I'd like to respond, just personally.
Yeah,
I apologize. I thought he was asking you a question.
no,
Not prior to.
no. So that's my opinion. I think we do need to discuss this. I think it's great it's been brought up. We need to control the pollution of this town. We need to control the streams of this town. I think it's a great thing to discuss, not in this hearing, not in this particular hearing. That's my opinion. Okay,
Got a motion and a second.
I have a motion and a second.
Would you repeat the motion, please?
He didn't read it very well.
No, Arrington, the motion is to deny the appeal request from Mr. Hamilton
Uh,
and
Or-
affirm the zoning administrator's determination that this stream does not require a 30-foot setback to it. Scott, you okay with that?
Yes.
Period.
Sorry.
And then period, no semicolon, period. And I believe Danny seconded my motion.
Any further discussion by the board members online or here? Motion's been put forth and a second is put forth. What I'd like you to do is each one of us versus what we normally do. I'd like to be, we don't have the secretary to call the roll. So I'd like for us to each one of us say, vote on the opinion individually. Okay, we'll start here.
I agree with the motion.
I agree with the motion. I guess I'll agree.
You made it.
Okay, online,
Aye.
Arrington,
I deny.
and I vote aye as well.
No,
I'm sorry.
I deny the motion.
Yes, you voted no.
I voted no.
So let's poll. We've got 5-1.
Mark, Mr. Chairman, I believe that Arrington needs to state why she is voting no.
It was an option, but yes, I prefer them telling us. Thank you for,
Just for the record.
yeah, that's fine.
I think this is going to cause, I think, building a house there on the ephemeral stream, which can, in a heartbeat, become a raging torrent and carry silt down this stream to Lake Susan, to Flat Creek, to Lake Susan, is a threat to the environment.
Thank you.
Thank you.
Okay, we have 5-1. Motion was,
Carried.
Chairman, can I make a motion to adjourn?
before we do that, it has been customary to offer, and we did not offer, we missed one. Is there any statements for the folks that do not have, that want to make a statement? I'd like to offer that opportunity.
I hate courtrooms and I hate quasi judicial hearings. I feel very vulnerable doing this. I really don't particularly like doing it. However, I have done a huge amount of reading in the area. I have a master's degree in anthropology. I have a doctoral degree in public health, nutrition, and epidemiology. I'm a statistician, good at least at an intermediate level. I can read scientific stuff. And for pleasure, I do read scientific stuff. And a lot of it is about watersheds and ecological communities and how watersheds work. So I think I'm perhaps an overeducated, but a fairly qualified public citizen. In my opinion, this entire valley is a watershed. Anywhere that water ever runs or ever has run in this valley, it will again. If we do not protect what we have, we run the risk of ever increasing runoff. When we start adding septic fields, we run the risk of polluted runoff because great amounts of water will go after those, over those septic fields, and they will flood. And sometimes they will seep. I think this was not the right decision for Montreat. And I feel like, well, from what I think I know about how watersheds work, if we don't keep water percolating into the ground from the highest point around the edge of the cove, then we will be starving our wells and our springs and our perennial creeks. And when you start digging into things like this scientifically, you always find a finding that, well, that creek doesn't really affect that spring. So we may have multiple systems in the valley, but the valley is a system and we all need it to keep working properly if it's going to remain a place that we can live. Thanks for listening.
Ma'am, before you leave, can you please state your name for the record?
Oh, Jean Norris, resident of 192 Mississippi Road, very constrained lot. Water flows an inch deep across my backyard in a heavy rain. There's not a lot I can do to stop it, but I'm trying to do a little.
I think we have an opening on the board.
Yeah.
Water wind.
Okay, anybody else like to speak? Yes, sir. Please state your name. And you folks, since you're not testifying as subject matter experts or anything, but it is your chance to speak.
Pretty much. I'm Eric
I'm Eric Nichols. I live with Grace Nichols. We're at 527 Suwannee Drive. I've been on this board. In fact, I appealed to Mark, become a member of the board.
You asked.
Yeah, well, I know. Am under the impression that there are state required 7 questions that you must go through and deliberate on in front of us before you can decide yay or nay. That's all I have to say.
I believe that's for variance, for granting a variance is what you're
This is
referring
not a
to.
variance.
That's, we always do that for variance.
Which is why if a variance does come up, it's perfect. That actually emphasizes the point I was trying to make. Variance comes up, you've got to consider all those things. Okay, anything else?
You entertain a motion
Yes, I will entertain the motion.
to adjourn.
Second,
Sure.
all in favor?
I didn't even have to get into my